Welcome to Garden Views. Interesting conversations with interesting people who have done and/or are doing interesting things. So sit back and enjoy. Welcome into Garden Views. This week we are talking to Robert Grundstein. Robert is a story that's not similar, but it's in the same vein as the guest we talked to about 2 to 3 months ago, Tony Oliva. I believe it's Oliva, right? Is that his last name? Viola. Oh my God! Thank you for that. I knew something wasn't right, but I had anyway. This is a story of basically prosecutorial misconduct, which ended up in another arm of justice coming in and dispensing justice onto the prosecutors, but not helping the individual at all who had been the victim of these wrongs. And it's sort of a strange story, much like Tony's was. And so I think we'll just start at the beginning. And first we'll greet Robert and say, Robert, thank you for coming on Garden Views, and just tell the folks a little bit about yourself.
Well, thank you for the audience. It's important to have an opportunity to tell my story.
Yeah, I appreciate that.
And just to preface, in response to what you said, as far as Tony Viola's and my happenstance being unusual, they really aren't. The sort of prosecutorial misconduct that occurred in both our cases is quite common, but it's just hidden because people are afraid to say anything. It's expensive to get an attorney. In my case, I was able to participate in my own legal defense. It's also frightening because you learn quickly that if you fight them, you get put in prison.
Now, your story began with really just a couple of civil cases where you were having civil issues. One you were helping a relative with, and one was between yourself and a homeowners association or condo association. And somehow, as a result of that, you almost got banned from the local courts. And we should probably give that a little bit of a background as well, because this whole thing started with you trying to deal with things in civil court.
Right. They're actually two parallel histories. Just in terms of temporal history. The first case was a civil case. I was a member of the Washington State Bar at the time, but I had to go back to Ohio to help my parents who were becoming in advanced age. They really just had to have someone with them all the time. We tried having home care help, but it just wasn't working. My father had, who was a professor at Case Western Reserve, really a distinguished intellect, professor of public policy and law. Also was having very serious health emergencies. They were acute, but they were serious, and the recovery periods needed someone there all the time. So I moved back to Ohio to really take care of my parents, who were in their middle 80s. And I'm glad to say, due to my presence, my father was able to die whole. He had these acute health emergencies, but because I was there, we were able to treat him, get him to the hospital the same day. And it was really one of the best things I've ever done. Instead of putting my humans on a sanitary waste heap of elder adults. So the first case was a civil case after my dad died. My mother consigned some of her collectibles to a fine arts auctioneer in Cleveland, Ohio. I don't know why she did that. We really didn't need the money, but she did it. And my sisters negotiated a contract with Wolf's Gallery. It was a fine arts auctioneer in Cleveland. Well, Wolf's took some of the collectibles, sold them, realized $30,000 from the sale, and gave my mother nothing. So I had to remain in Ohio and help my mom get her money back. It's just taken the loss, but you have to be just out of loyalty, and the idea that someone was treating a newly created widow like this was intolerable.
Sure.
So I had the proceeds of the right to the proceeds assigned to me, so I could sue in my own name, and sued and filed the first case I ever filed in Ohio, ever. First case. And it was dismissed on a procedural basis. I appealed and won the appeal, and it was remanded to a judge named Lillian Green. So once it's remanded, the case starts new. So we're doing motion practice, and it was a very good case, really. Not only was it, on behalf of my mom, who was a very benevolent person, but it was also litigating limited liability corporations, which were quite new at the time. There just wasn't that much law on them. So it was very healthy for the legal system. And what I was trying to do was called piercing the corporate veil to get personal liability against the Michael Wolf, who was the principal of Wolf's Gallery, Inc. So we're doing, you file your briefs. I think things are going quite pleasantly. There were no Rule 11 motions, which are motions for frivolous filings or things that are not correct in law and fact. There was no contempt. There were no warnings. There were no violations, other technical violations, like res judicata, like bringing a case for a second time after you've lost. Nothing, really. But Lillian Green, the judge, just didn't want the case. So opposing counsel, out of the blue, made a motion to have me declared vexatious under Ohio's vexatious litigator statute. I didn't even take it seriously, because under the statute, you can't do it by motion. I had done nothing wrong. It's for serial filers, people who file the same suit or same motion over and over and over and over. And I'd done none of that. It's a very responsible case. I'm a good writer, and my research was very good.
Even if it wasn't, you're correct. Vexatious means that you've abused the system, like you said, over and over and over again. So even if this one case was hideously flawed, which it wasn't, you won on one appeal at least, it's still one case. Definitionally vexatious, which I'm not even sure all states have such a statute. I know mine does not, but I can figure out what it is. But whatever it is, it's extreme. It's not for, one case that goes bad or south. It like you said, it's for basically a course of conduct.
Right. Also, the Ninth Appellate District in Ohio even declared the statute unconstitutional because the term vexatious has no meaning.
Right.
And it makes no reference to objective criteria like violations of Civil Rule 12. It doesn't make any reference to objective criteria. So to me, this was laughable. I said, this is not professional. This is not even pre-intelligent. So he makes them, and plus, under the statute, you're not allowed to do it by motion. It has to be a new action, a new complaint, filing, service, and a new trial. So to me, this is just laughable. This guy was desperate. So anyways, the judge grants the motion. I couldn't believe it. I said, what have I walked into? I've heard bad things about Cleveland, but this. So, she grants the motion. I'm hereby declared vexatious in Ohio. And when you're vexatious in Ohio, you can't file in any court. You can't file in the lowest municipal court, court of common pleas, appellate court, the Supreme Court, in any county in the entire state, in any 86 of the counties. One court determines jurisdiction for the whole entire state. And you can't appeal unless you're given leave to proceed. So it's an excellent vehicle for silencing people they don't like. And I think Lillian Green just couldn't keep up with the docket. She just wanted to get rid of someone who didn't represent advancement. I wasn't one of the big law firms. I didn't represent loss. I was too small to protect, too easy to remove. So anyway, I filed my appeal in a timely manner. And the appellate court didn't say anything. They didn't say, well, you have to ask for leave to appeal. I paid my fee, sent in my brief. They sent the brief back if they wanted it respaced into double space, which I did. And this was all in 2005. In October of 2005, I get asked to come into Ohio in March of 2006 for oral argument, which is a normal part of appeal. So in March of 2006, I drive into Ohio and go to the 8th District, 8th Appellate District. And I remember the bank of judges. I remember them very clearly because it was a very unusual bank of judges. They had a pro tem judge, a guy named Corrigan. The Corrigan family runs Cleveland. And they had a pro tem judge, sitting as lead, which is very unusual. And I recognized the other judges. One judge was Judge Karpinski, Diane Karpinski, who was very bright. She once offered me a job. I said, what's going on here?
What does pro tem mean?
Walk up to, pro tem means temporary.
Okay.
That's, a special assignment on a sort of an ad hoc, one-time basis.
Right. So they're not usually sitting there. They're assigned. Yeah. Probably a retired judge or something like that.
Right, for a special purpose. Well, this guy was not retired. He was quite active, but it's sort of like for a one-time purpose.
Mm-hmm.
What do they need a one-timer for? This is a very routine case. So I walk up to the podium with my brief, and I'm ready to start talking. They say, Mr. Grundstein, your appeal has been canceled. I said, what do you mean you can't cancel my appeal? You took my brief. I paid my money. I filed timely. You had me drive in from Vermont, where I moved after my dad died. My mother moved to Seattle after that. You can't do this. I said, sorry, you don't have leave to appeal. Appeal is denied. You are vexatious for the rest of your life. That's another thing about the Ohio Vexacious litigator statute. You're vexatious forever, which is unusual because one is not necessary. If you look at the federal cases, there's a leading case it involves Crummer versus Kraft Foods. And that federal case says you can only apply filing restrictions with respect to one party, with respect to one cause of action in one case in order to stop something that shouldn't be happening right now. It's a good application. So that's it. So once you're vexatious, you're completely exposed. You're also have the stigma of being vexatious. They say you're incompetent, you're irresponsible, and the judges talk to each other. They know that this is a person we need silent. So there I am, vexatious, in defense of my newly created 87-year-old mother, who's a newly created widow. I mean, if there's one person who should be able to be defended, it's her. But the priorities of the legal system there is, to a certain extent, it exists for itself. These people, you have a situation where people have made careers. Judges have to run for re-election every 6 years. And once you've left private practice or employment, your next problem is, how do I get re-elected? And you do that, especially where judges are elected, by pandering to the local interests, the large firms, the Bar Association, other judges, and the people, the quiet people we cannot see who run a city, the people who choose people who are allowed to run. This thing is always, governments are run by people we cannot see. We think that the legal system is an analog, not an analog. We think it's a system of non-discretionary activities. If A, then B, then C. You read the statutes. Okay, this means this, and here's the procedure. But it's not. There's also a lot of personal favors. What makes it difficult is it's not bad all the time. So there's some times when it works quite well. There are other times when it fails badly. But Cleveland had deteriorated so much that the FBI was forced to raid it in 2007, 2008, and into 2013. 160 people were indicted. Judges, prosecutors, county executives, contractors, administrators went to jail. It was very serious, and the FBI raids actually, they're very expensive, and they started their investigations in the year 2000. So they put 7 years of work in before they actually moved in and started arresting people. The county prosecutor, Bill Mason, had to resign. The chief clerk of the criminal courts, Mark Lime, was put in prison. Another prosecutor, Joe O'Malley, who we'll discuss again later in this interview, was put in prison. There's many people, and many of them were actually related to my next happenstance. So, while I was taking care of my parents, I had an opportunity to buy a condominium in Chagrin Falls, Ohio, which is a suburb of Cleveland. And I discovered that the homeowners association there had charged $150,000 for a new roof in the condominium. It didn't seem right, so I called the contractor. Said, "How much did that roof cost?" He goes, $75,000. I said, "Do you know they've charged us $150,000?" He goes, "No, I can show you the bills if you want."
Okay, folks, thanks for bearing with us. We had a little bit of a technical issue, and we have Robert back with us, so hopefully we didn't miss too much, but if he has to repeat a little bit, you'll understand why. All right, Robert, you were talking about how the second case was situated with the homeowners association, where they were billing the homeowners approximately twice as much as what the contractor actually charged for the job, and that was a tune of $75,000. So that's sort of the last I heard. So I guess you can pick it up from there.
Right. So they charged us $150,000 for a roof that cost $75,000. I looked into the management company. Turned out they had a terrible reputation, and they wouldn't give me any documentation, so I sued them. It's called a derivative suit, which you file for the benefit of the corporation to preserve its financial integrity and well-being. You sort of file for everybody in the condominium.
Right.
It's not a suit to make money for me, although I did have a direct action in which I could my portion of the money paid.
Right. Whatever your portion of is divided by, the number of homeowners into 75,000 or whatever the number would be.
Right. So there are two ways of suing a corporation under this circumstance: a direct action or derivative. I did derivative, and the local court jurisdiction for Chagrin Falls is Bedford Municipal Court, about which I didn't really know anything until later. But it turns out Bedford Municipal Court has a real history of criminal activity among its judges.
Is this Ohio also?
Prosecutors and law directors. This is Bedford, Ohio.
Okay. So obviously this is before
the condominium is in Chagrin Falls, Ohio. Excuse me, go ahead.
This was before the Vexacious decision.
No, this was after.
Oh, okay.
The Vexacious thing was playing out in 2005, 2006. Then, in 2007, I was conducting the suit against the Owners Association.
How were you able to file the suit if you had already been declared vexatious?
It happened. I filed it before I was declared vexatious.
Okay, so it was pending.
That is to say, I filed it in 2000 and early 2006 before I was declared vexatious.
Okay, just so we understand.
I was sort of able to go under the rug.
Gotcha.
It did become an issue later.
Right.
In the case, they were sending files back and forth. They decided to let me, they decided to let me continue. But so I filed, and I was in Bedford Municipal Court, and I had a judge named Peter Junkin, who was later removed from office during corruption scandals. Derivative suits they're unusual for municipal court judges. They can be complex. It's a strange form. There's more briefs than they like. And so anyway, I filed, and the judge asked me to come in for a motion hearing from Vermont. So I drove in from Vermont. This is in early 2007. We had the motion hearing. Opposing counsel was a local counsel from a very prominent firm in Michigan Falls. Very high-powered, very connected. And it was odd. He didn't know the file. He didn't know the facts. He was flipping through the pages to learn about the file while I was, presenting my argument. It was a motion to dismiss. And he just didn't know the file. He kept on making remarks about something he'd find in the file that he didn't like. But they weren't legal criteria. It was like he was making it up. He wasn't prepared.
Right.
So, meanwhile, he's falling all over local counsel, giving him anything he wants, and he dismissed the case. And I have a 1,500-mile round trip. I expected more responsible analysis in this. So I called the law director, a guy named Burdick, and said, this is very bad, and I'm going to publish an editorial. Not only send it to some of the local periodicals, but I'm going to pass it out on the courthouse steps in Bedford Municipal Court. Can you tell me what the security limitations are? I really don't want to obstruct, traffic or on a busy day. I don't want to do it wrong. I'm not going to, go in there and make a scene. But people have to know this sort of irresponsible, cavalier behavior is being practiced by judges. So I wrote the editorial, passed it out on the entrance to Bedford Municipal Court. This is in April of 2007. And drive back to Vermont. Okay, this is First Amendment, free speech, not a big deal. I won't make any friends, but that's what the First Amendment exists for, is to hold public officials accountable. So 6 months later, in October 2007, I'm sitting in my place in Vermont, and the state police show up. I know them, because I helped them with a couple things. And I say, what's going on? They say, well, there's a warrant for your arrest in Ohio, and you're being extradited. He said, not only is it a warrant, it's a felony warrant. I said, well, this is alarming. So meanwhile, they're handcuffing me and taking me off to jail, to a holding cell. And because I know the guys, and I know the police, I said, what do you have? This is something really wrong here. So he showed me the affidavit for the warrant. And as soon as I saw the affidavit for the warrant, I could tell this is a stupendous lie. What they did is, in retaliation for passing out the editorial and sending it to different periodicals in the area, the judge, Peter Junkin, went to the Cuyahoga County prosecutor and said, bring something, find something on this guy or make something up. So what they did is they made up this set of facts, and they presented it to the grand jury in June of 2007.
Yeah, I want to tell the audience what it is, because it's really outrageous. And you can correct me if I got anything wrong, but as we spoke in pre-production, and as I recall it, you had purchased a gun lawfully in another state, West Virginia, I believe it was, and in Vermont. And as part of the background check, you filled it out and completely and thoroughly, but there was one statute that you had named, which shouldn't have mattered anyway, because it was not a disqualifying statute, period, but they wanted more information. You simply added the subsection, C or D or whatever it was. This went to the FBI. They're like, fine, you got your firearm, achieved it lawfully. Somehow Ohio saw this and said that not only was it fraudulent, but somehow it was fraudulent on Ohio, even though Ohio... All right, folks, thanks for bearing with us. We had some technical issues again. So I was sort of summing up what the case in Ohio was now, so basically this municipality in Ohio was attempting, they filed charges for a non-criminal act that, even if it was criminal, would have been a crime in Vermont, not in Ohio, possibly a state charge, possibly even a federal charge, but whatever it was, not Ohio. And yet they did so anyway, and that picks us up where we left off.
Well, actually, it was not a crime anywhere. What happened was, and your rendition of the events is true. What happened was, I went in Vermont. They have a point of purchase security checks when you buy a handgun,
Mm-hmm.
and it's called the NICS check, NICS. And what happens when you buy a gun? You go to the cash register, and the gun owner, the shop owner, will call the FBI, which has a line, an open line in West Virginia, and they say, "Is there anything on this guy?" There's certain, like, if you have a felony, you can't get a gun.
Right.
If you have ever been committed to a mental institution, you can't. There's a restraining order against you for domestic abuse, that sort of thing.
That was a red flag law.
Right. And so they said, "Sorry, Bob, you can't have the gun because, something came up on you." I said, "What is it?" And they said, "Well, in Ohio in 2002, 2001, you were fined on the lowest misdemeanor in Ohio was a misdemeanor with the 4th degree for improper storage of a firearm." So I said, "Yeah, that was true. You have to have your firearm in a lockbox in your trunk in a car in Ohio. My car was towed during a rush hour violation. The police unlocked it, went through everything, and found my 22 caliber pistol, semi-automatic. So technically, that was a violation of the law. I went to Ohio, was fine, went home, and that was at the end of it. So it was the lowest misdemeanor in a court which only hears misdemeanors, Lakewood Municipal Court, which is a Cleveland suburb. I drove back at the time. I was involved doing investigation on my mom's case for the fine arts auctioneer. So in 2007, so anyway, when I went to buy a gun in Vermont, I asked them to send me, what the problem was. I asked for correspondence from the federal agency in West Virginia. And they said, "Bob, you see in early 2001, 2002, you were convicted for improper storage of a firearm, and we cannot tell if that's a misdemeanor or a felony, because in Lakewood, misdemeanors can have up to 1 year imprisonment, and in some jurisdictions, 1 year imprisonment means felony." So the FBI asked me to send a copy of the original order. So I wrote to Lakewood Municipal Court, asking for the charges, the police charges, in the court order. Got a copy of it, and the statute was Lakewood Municipal Code 54904C, which is a misdemeanor statute in all its subsections A, B, and C, but it was missing the C, which is irrelevant because it's still a misdemeanor in a court that only hears misdemeanors.
Right.
So in green ink, I added the subsection C, wrote a letter to the FBI saying, "Well, I wrote on this copy of an order to add the subsection, but it doesn't matter anyway because you can see 549 is it's misdemeanor in all its subsections." And I also sent them the portion of the Ohio Constitution which assigns Lakewood Municipal Court as a court which can only hear misdemeanors with only misdemeanor jurisdiction. If you have a felony, it gets bound over to the Court of Common Pleas. So the FBI said, "Oh, okay, no problem. We see, writing on the order is not that great, but it's not a federal crime. It's not a state crime. It's not fraud. You didn't, change a felony into a misdemeanor. No problem. Go back and get your gun."
Right,
So
and whatever it wasn't in Ohio.
Well, it doesn't matter. I mean, because there are federal laws. If you utter a falsified document to a federal agency, that's a federal crime.
But was this from a federal prosecutor or was it from a state prosecutor?
Well, what happened was when the FBI couldn't tell if my improper storage of a firearm was a felony or a misdemeanor, they asked me to get the original court documents from Lakewood, Ohio, where I received the criminal charges.
Mm-hmm.
So what you do is you go to Lakewood Municipal Court and you ask for the police charging document, the criminal complaint, which said Lakewood Municipal Code 54904, and then you look at the conviction, the court order, which says 54904, and then you show they're all misdemeanors in a court which only hears misdemeanors. And you send that to the FBI because they just wanted to know if I was accused or found guilty of a felony in Ohio.
Yeah, but I'm just trying to figure out what authority in Ohio even filed for these charges.
Well, what happened? You mean the original improper storage of a firearm charges?
Yeah. Mm-hmm.
Yeah, I had to go back.
No. Who filed them? Like who in Ohio filed them?
The Lakewood Municipal Police.
Right. So they are not federal. They're municipal. So yeah, it's a federal statute, but this is not something that the Baltimore City doesn't file federal crimes. The U.S. Attorney's Office in Baltimore City files federal crimes. I live in Baltimore County. Baltimore County doesn't file federal crimes. The federal government would do so. So, what I'm pointing out is that they filed something that was not even in their jurisdiction.
Well, it's really, I would say, I think, Jeff, that if let's say the FBI sitting in the office in West Virginia, who's doing the Nixon investigation, they had to determine if I was, convicted of a felony or not. Because if I had a felony conviction, I wouldn't have been able to get a gun. And if I present documents to them, even though from an Ohio municipal court, that I changed, let's say I changed, a felony count into a misdemeanor and presented it to the FBI, that is a federal crime. There would be federal jurisdiction for that, for uttering a falsified document to a federal agency. There'd be federal jurisdiction for that. Very serious.
Okay, I'm not.
You'd also have state liability too.
Well, I'm not doubting that there'd be federal liability if there was a crime, or even if they made a mistake. It's federal, but there wouldn't be something in Lakeland County for it.
Oh, Lakewood, Ohio, is in Cuyahoga County, where Cleveland is.
Mm-hmm.
But basically, I just wrote in a different colored ink with on an administrative order. I mean, it's a court order, but I wrote on it in a different colored ink, sent a letter to the FBI saying they left out the subsection, but it doesn't matter because all the subsections are misdemeanors.
Right.
And I drew their attention to it and drew in a different color ink, and they said, okay, no problem. You haven't fooled us. You haven't committed fraud, which is a material misrepresentation. Go get your gun. You haven't committed a crime anywhere. You improper storage of a firearm. Be more careful next time. We don't care. So I got my gun. So after I read the editorial, skip forward 5 years later to 2007, after I wrote the editorial about Peter Duncan in Bedford Municipal Court, being extradited to Ohio on felony charges. So I look at the documents, and I see the documents which are the basis for the affidavit. The arrest warrant comes with an affidavit. And they said in April of 2003, which is exactly the time I was applying for the gun, that I falsified the court order in the possession of the court clerk in Ohio. So, I wasn't in Ohio on those dates. In addition, the statute on which they relied involves 2 felony counts. One is alteration of a will to get more money for yourself, or 2, altering the original of a court document in the possession of the court clerk. Like, let's say you're an attorney.
Right.
You ask the clerk to look at a file, and you change $1 million reward into 25 cents.
Right. And none of
falsifying
the...
driver's license.
Right. None of those
in
things...
Ohio at the time. I was in New Hampshire and Vermont doing small construction projects.
Right, and these were not court documents in possession of the clerk. I mean, it failed on almost every level you can think of. Yet you had to deal with it, and as I recall, you made numerous trips back and forth from Vermont to Ohio to try to deal with this thing, and they would never let you appear via telephone or have your appearance waived. And almost all of these were procedural or prosecutorial requests for postponements, which you never got any advance notice of the filings or the rulings. And that, I mean, you spent inordinate amounts of time making this 1,500-mile trip back and forth, something like, 10, 12 times?
Yes. Right. And the interesting part of this is, as I got to know the file, I saw that in June of 2007, the Cuyahoga County prosecutor presented it to the grand jury, and I got a no bill. The grand jury refused to indict. No one gets a no bill. I mean, they say, you could indict a ham sandwich. The grand jury refused to indict me. Now in Ohio, you cannot represent. There is a case called Freilich versus Ohio Board of Mental Health, which says to represent is malicious prosecution. Plus, I wasn't in Ohio, and I'd never done anything wrong morally, ethically, or legally. And I wasn't in Ohio at the time on the affidavit. I wasn't even there on or about April 28, 2003. So they represented anyway. And so, as you've described, you have to go in because you're being extradited. I made a deal with the prosecutor saying, don't extradite me. It's a 2-week bus ride, chained to the floor of a vehicle, because they take you all the way. It's a very circuitous route. They go through a lot of different states, Vermont, New Hampshire, Massachusetts, Tennessee, to pick up people along the way, and the bus keeps getting worse and worse and worse. So basically, you're in an armored vehicle, chained to the floor for 2 weeks. So I made a deal with the Vermont prosecutor who was responsible for getting me to Ohio. I said, listen, I'll go immediately. I'll just go immediately, stay in touch with you all the time. So I drove into Ohio for my arraignment. The bail commissioner looks at this and said, you shouldn't be here. You haven't done anything wrong. I'm going to let you go, even though you're from Vermont, with no bail on your own personal recognizance. I said, well, that's good. So you go in for your arraignment. You plead not guilty. This is in October of 2007. And then I made some motions. I said, one, can you please dismiss this case? I got a no bill, and it's illegal to represent. There's a brand new case in Ohio. It came out in August of 2007, the Freilich case, which said it's malicious prosecution to represent. I got a no bill. Two, an alibi defense. I wasn't in Ohio on or about April 28, 2003, which is the date on the affidavit for the warrant. I wasn't there. So you submit these motions, and the judge refused to rule on them. The judge was Michael Russo. And this is odd. Why wouldn't they rule on them according to the rules of Ohio, the rules of superintendents of the court? They have to rule on motions within 120 days. Mm-hmm. No rulings. So I said, well, this is really getting out of my control. They're not following the rules. No one cares. And I'm not making decisions. So they had me go in and again after the arraignment in October, second trip in October 2007. And you drive in and you meet with them because you have to go to pretrial conferences. Right. If you don't go to pretrial conferences, they issue a bench warrant. I said, can I appear by phone? They said, no, you got to be here. So I drove in, go to this room, and the prosecutor says, will you take a misdemeanor plea? I said, no, I haven't done anything. Not only that, I'm virtuous. I'm right, you're wrong. I'll go to trial. Fine with me. This is easy. So I said, okay, thank you. Go home. So after a 1,500-mile ride, we had 10-minute They did this again in December. Same pretrial conference. You want to take a plea? No. They did it again in January. They did it again in February. But no, I'm not doing this.
Right.
So by then I applied for a court-appointed attorney, and he was doing a terrible job. I just wasn't important to him. I was doing all the paperwork, and he was missing appointments. Like I'd come in for pretrial, and he wouldn't be there. Or one of the pretrial conferences he actually forgot to tell me about, so I missed it, and there was a bench warrant, so I had to come in for that. But the trial was scheduled for early March in 2008, so this is great. I'm going in. I called the local TV station there, WKYC, and said, this is going on. You guys, does this interest you? I know I'm sort of small potatoes, but this is quite bad. So I go in for trial in the morning. I drove all night. During one of these trips from Vermont in the winter, I actually hit a deer. It was very icy. It was horrible, very, very risky. I damaged my car and hurt the poor deer. So I go in for trial. I'm there on time. I see these guys setting up cameras. I said, wow, this is good. So I'm sitting there, I have a trial set for 9 o'clock. And I'm sitting there. And the judge never called the hearing. So I sat there for the whole morning. I said, well, maybe, they say at 9, but it's a cattle call. They put people ahead of you. There really weren't that many other parties in the courtroom. So I waited till lunch, then went back in the afternoon, sat there all afternoon, went back into the bailiff's office and said, are you going to hear this case? I'm here from Vermont. And she shouted at me. She was very angry. I went to the prosecutor's office, and they were angry at me for, said I shouldn't be talking to them. And then they were closing down the Justice Center. They asked me to leave. So I drove in for a trial, which they wouldn't give me. And they said, go back to Vermont. This is like trip 6 or 7. But no trial. And so I go back to Vermont. And I noticed on the docket, for all these pretrial conferences, the clerk of courts was always saying that the trial is postponed. That's because the defendant, me, asked for a continuance. They do this to spoil your right to a speedy trial and how you have to have a criminal hearing within 90 days. But I never made any motions for continuances, and continuances in Ohio have to be signed by the defendant. And there's no paper trail. I always wanted a trial. And every time they had me come in for a pretrial conference, on the docket it said, defendant has asked for a continuance. Well, I didn't. The pretrial conference was not my idea, and I never asked for a continuance after them, because I wanted to get this over. So they were falsifying the docket. And as it turns out, the docket chief clerk of criminal courts, Mark Lime, during the FBI raids, was later put in prison on 37 counts of docket falsification. They lost their credibility, and eventually I asked the public defender to take my case, and he agreed to. A man named Bob Tobick, and he said, oh, this is what they always do. He said, what they do is they have you come in for a lot of pretrials, and normally, someone loses their job after 5 pretrials, and they force you to take a plea. He said, you're really doing quite well. You're really standing up there, Bob. Well, thank you. So there was another pretrial conference in April. I refused to take a plea. They set another trial for June. I drove in during June. Same thing. They canceled the trial. Wanted to know how I would take a plea. I said no. And my mom died in July 2008, and I had to have abdominal surgery. So they called me in September for another pretrial conference. I refused to take a plea. And they set a third trial for October of 2008. It was about my 11th or 12th trip. And before I was ready to go to trial. And the judge had still not ruled on any of my motions. And even more seriously, I never got a pretrial hearing, which is under Criminal Rule 8 in Ohio. After arraignment, you get a pretrial. You get a pretrial where the prosecutor presents his evidence. I present my evidence, and he decided, do we really want to go forward with this? And was given a pretrial. I would have shown him I wasn't in Ohio. I got a no bill. They can't represent, and I committed no crime. Writing on an administrative order without changing the content of the order is not a crime anywhere. It's not a crime. It's not morally wrong, and it's not ethically wrong. And I had the alibi. But they didn't give me my pretrial hearing, which you get. They wouldn't rule on my motions to dismiss. So in October, this is going on for a year, I drive in, and public defender, Bob Tobick, very decent guy, he says, listen, Bob, this is going to go on forever. And, we just don't have any confidence in anything that's going on here right now. They could find you guilty and put you in jail even though you haven't done anything. So here's what they're offering you. A $50 fine, no probation, and you agree to a lesser charge of altering a court document, some misdemeanor charge. I still don't even know what it meant. I can't remember the statute. They said, we'd hate to see you in an orange suit, Bob, in jail. So my own defense counselor, who's the public defender, Bob Tobick, was the head of the public defender. He was the chief public defender in Cleveland. If he's saying this, I got really scared after all this. So I said, okay, I got to take this. I can't do this anymore. I can't make a living. So I took it. So that was the name of that tune. But also what they did, I was a member of the Washington State Bar at the time, is they sent an anonymous letter to my state bar saying I had been indicted for a felony, which got me in enormous trouble with my state bar. Just the filth of this thing was overwhelming. I've never expected this to be like this. You think the legal system is an algorithm. If this, then this. You have this right. This right is exercised. You have the pretrial hearing. If you have an alibi excuse, the judge hears it and rules on. If you've got a no bill, you're not allowed to represent. The judge will dismiss the case. But there was this huge silence. They wouldn't act. And it turns out that everybody in my case was eventually removed from office. Peter Junkin in Bedford Municipal Court was put out. The prosecutor, Bill Mason, for Cuyahoga County, which was responsible for my felony charges, was forced to resign. And the chief clerk of courts, Mark Lime, was put in prison on scores of docket falsification charges. And I'd like to say a bit about Bedford Municipal Court because there are several new developments there. Is that okay?
Yeah, but let's underscore what you just said. That basically, everybody who was lined up against you, who had made your life miserable and never backed down, there's been enormous repercussions to them legally from federal authorities, which is a little bit ironic since they tried to use some federal, law and then somehow shoehorn it into Ohio and use it against you, which caused you so much of the heartache. You could say that some level of justice has occurred, but not for you. You're still walking around disbarred. You're still, you still haven't gotten any of your cases advanced. So, you're sort of like the forgotten one here.
Yes, and had I done anything illegal by state law, federal law, or even disingenuous, I would be ashamed, but I'm not. I decided I'm dying on my feet and not on my knees, and someone has to do what I'm doing. But it turns out my criticisms against Bedford Municipal Court were also confirmed. It turns out that Bedford Municipal Court had a prior law director, prosecutor named Tommy Longo. Tommy Longo was removed from office and actually arrested in Mexico on a federal warrant. Tommy Longo had been dealing drugs with the local mafia in Little League, Cleveland.
Wow.
He'd been committing date rape, giving girls drugs. and then assaulting them sexually while they were unconscious. He had weapons violations. He was actually on America's Most Wanted, believe it or not, that old TV show. And he was arrested in Mexico on a federal international warrant. And he was a law director prosecutor. Then Peter Jungan was removed. Then another judge, Judge Jacobs, was removed recently for activities supporting prostitution. And the law director, a guy named Ken Schuman, was also removed from office for the same activities for promoting prostitution. So there you have two judges, two law directors, and a prosecutor at Bedford Municipal Court who were removed from office on criminal charges. And there's another person, Joe O'Malley, who would act as a prosecutor, sometimes pro tem in that jurisdiction. And Joe was, during the FBI raids, Joe was put in federal prison for committing perjury to the FBI during its investigation. So we have a real cheery bunch of people running things. And they were all involved in my case because Joe O'Malley also brought charges against me in a local jurisdiction that they were later dismissed. But it's just, unless you're a criminal, it's difficult to participate in Cleveland's legal administration.
Absolutely. So, has anything changed for you, period?
Well, no, I mean, you fight the fight. You make your choices. I mean, one of the things my father was a professor of public policy and law, and he used to do executive development, for post-PhD executive development for private and public entities. And my father was quite stern and said, you have to stand alone with your view of life. It's hard, it's lonely, but it's honorable and it's clean. You have to fight your fight, which is a good way to be raised. Nothing wrong with it. And, if you try to accommodate the group and conform to the group at the expense of really important principles that support us all, then you failed. So people go to war. They risk their lives for things they believe in. I wasn't risking my life. But I said, I'm not caving in. Someone has to do what I'm doing. So I did it. Most recently, I was lucky, and in 2017, the vexatious status was removed against me. The judge who was administering my case, my vexatious status, inherited from the first judge, Lillian Green, a judge named Lance Mason. And Lance Mason refused to remove the vexatious status. But then Lance Mason got removed. Judge Lance Mason himself got removed after he murdered his wife.
Okay.
He's in federal prison for a very long time. And this is after he assaulted her once and broke the orbital bone, broke her cheekbone, really hurt her. So when Judge Mason was put in prison, I applied to the court just to, this has always been a mistake. Can you remove this? And he said yes. So I was not and as of 2017, I was not vexatious.
All right. Well, that's one victory.
But in 2019, they reimposed filing restrictions.
Oh, great.
It was a judge, another Judge Russo, a cousin to Michael Russo, Judge John Russo, who's administrative judge, reimposed them. I said, well, because they found out about the book I wrote concerning the FBI raids in Cleveland, exposing all this. I get this notice from Cleveland that filing restrictions have been imposed on me. And I said, well, how can you do this? I didn't have a case in Ohio. I wasn't conducting a case. I was not served with a complaint. There was no motion hearing. know nothing. They just do this because I've embarrassed them and someone asked them to do this. It's just, we're a people in decline. If this can go, if this can happen, I'm very worried about our country.
Well, it's a horrendous story, and the story that Tony told, while different in the details, is a similar type of symptom and very, very scary. So why don't you tell the folks a little bit about your book, where they can find it, and where they can find out more information? Because we're sort of getting to about the 1 hour mark, which is usually where the show ends. So it's probably a good time to promote whatever you have to promote and let them know how they can support you and find out more information, should they be interested.
Sure, thank you. The book is called Bad Minds, High Places, America's Archipelago of Legal Failure. And it's on many, many websites. Most prominent, easiest place to get it is on Amazon.
Okay.
Very easy to get it there.
Sure.
I'd like to say one more thing if I can.
Of course.
I'm not the only person who's been oppressed by this vexatious business. There's a very distinguished person. A woman who was a pharmacist and an attorney who was active in local politics in Sandusky. And her name is Elsbeth Baumgartner. And Elsbeth found that one of there was some financial irresponsibility, some local payoffs between local energy companies, some illegal financial relations between local energy companies and politicians in Sandusky in that area. And she exposed it. Next thing you know, she's arrested, put in jail, declared a vexatious litigator, loses her bar license, and as Elsbeth put it, she said, you just suffer a long, slow death. Right. So I'm not the only one. And there are people who are just as accomplished, as educated and well-meaning, who behave responsibly, who've been subject to organized activity by the people who are supposed to protect us.
Well, it's probably good to not be the one that's singled out, but I think on the grand scheme of things, it's probably worse news. This is, I don't know if it's enough to be a pattern, but that it's been repeated and it's a tactic. And it's a very heavy-handed tactic, and it puts the attorney or the plaintiff, the litigant, on defense. And not just, on their back foot or their heels, but it puts them down in a hole under a hat, like a hatch in the hole, and the hatch is locked. I mean, you're like in the sub-basement of a hole, and you're locked out. I mean, and you have to, it's like the show Lost. You have to, solve 7 mystery boxes before you're even back in neutral. And then you still have to fight the case. And I mean, it's exhausting. It's expensive. Luckily enough for you, luckily is a strange word to use, but you were, a lawyer, and you were able to do the pleadings yourself. But most other people couldn't and can't. So really, this was some shocking stuff. Thank you for sharing it with us. And folks, go check out his book and everything else he mentioned here, and check out the show with Tony as well. I believe it's called The Federal Prosecution Story That You Won't Believe. That was the very clever title of the story of that show. And it's within the last 12 weeks. So check that out. And Robert, sorry for everything that you went through, but thank you for sharing your story with Garden Views and with the world, and keep on keeping on.
Well, thank you for the opportunity. It's always good to be heard.
Absolutely. Okay.
The courts won't do it. So thank you again.
You're very welcome. All right, folks, thanks for listening to Garden Views, and hopefully you'll tune in again next week. And if you have a chance, give us a rating and a review, a referral. Let your friends and family know, because this show is sort of genre defined. So appreciate that, and you'll hear from us next time.
Restrict you and restrain you. They rented special shackles from the state of charge.
Base. I was over at the quarry swinging naked from a tire. We didn't set no fire. Love is his alibi. I said love is his alibi. I can place him at my scene if you know what I mean. He was with me from approximately 12:15. If you call me as a witness, I will gladly testify. Love is his alibi.
They'll nail ya, they'll jail ya, they'll say that you're a failure.
We certainly appear to have you by the genitalia.
They'll charge you with resistance even if you don't resist them. No matter what you do, you know you can't beat the system. No, you can't beat the system. You mock it, you knock it, you kick and shake and shock it.
How dare you come before this court and desecrate my docket? But there will soon be justice here, 'cause you're about to see. You're looking at the system, and you can't beat me.